Moving on to Italy. Our next speaker is Alessandro Mantelero from the Polytechnic University of Turin, and he's going to talk about the right to be forgotten. And two things already occurred to me while listening. One, it seems rather surprising that the law in the EU is supposed to be harmonized. And two, it's also rather surprising that intermediaries having an immunity. You don't get much of a sense of an immunity so far. But over to you.
Thank you very much. I'm one of the last speakers before dinner, so I try to be quickly. My presentation is a sort of anticipation coming soon about the section that we'll have tomorrow on the right to be forgotten, and it's mainly focused on a specific aspect of the right to be forgotten that is represented by the information that is in the archive of the journals that are available online. And the presentation is divided into three different parts. The state of the art before the Google Spain case, the different approach adopted by data protection authority in Italy after the Google Spain, and a bit insight about a new aspect that is not strictly related to the right to be forgotten in terms of protecting personal information that are published in the archival newspaper, but is important because on this question there is a specific request for a preliminary ruling from the Italian Court di Cassazione to the European Court of Justice. In Italy, we have a long history about the right to be forgotten because the leading case was in 1979, the Turin case, and there are many decisions adopted by the Italian tribunals and the Court of Appeal and also the Court di Cassazione on the right to be forgotten in the field of media activities. And the notion of the right to be forgotten is the notion that we know also in French, the droit d'oubli, and is the idea that this right represents a sort of limits to the media activities, forbidding media, press, TV, to make public once again aspects of personal life that were the object of public interest in the past. So, if something was published in the past, the right to be forgotten limits the chance to republish this kind of content. And if you do that, you have to pay for damages in this case. It's considered a part of the more wider right to privacy in the Italian case law. And the criteria that are adopted in order to make a balancing test between the right to be forgotten and the freedom of expression, the freedom of press, is represented by the nature of the fact, the nature of the people involved, if they are public figure or not, and the core element is represented by the public interest. If there is a public interest at the moment in which the fact happened, and still in the moment in which the facts are published again, you are able to publish it. If there is not this kind of public interest, you are not able to republish this news. And the public interest could be also related to something new facts that involve the same persons, or new event related to the same events that happened in the past. So, for instance, there are some cases that are related to new legal action about former crimes and so on. More recently, with regard to Section Giant, the legal action mainly against Google, was brought before the Italian Data Protection Authority, also because it's actually expensive than the traditional court. And the Data Protection Authority, with regard to the information that are made available in the online archive of the newspaper, adopted the same criteria that are already known in the Italian case law on the right to be forgotten. So, public interest, the relevance of the fact, the relevance of the interest at the moment in which the content are still available online. The initial position of the Data Protection Authority was that there was not any chance to make an injunction against Google, because Google was considered out of the territorial scope of the national data protection legislation. As a consequence, the strategy of the data subject changed, because they make legal action against the content providers, and the data protection authorities adopt a solution to make an injunction that asks the data controller, the content provider, to change the draw.txt, that is the file that is used to say to the crawler of Google which content could be indexed and which content could not be indexed. So in this, with this solution, the content are still available in the online archive, are searchable by the internal search engine, but are not searchable by Google or other general search engines. It's interesting because more recently, in 2012, the Italian High Court, Corte di Cassazione, said that give a broader, extensive interpretation of data subject rights, and said that the data subjects are also the right to add new content to the existing information that are in the archive. So if in the archive there are some information about a past event that involve you, you are able to add content in order to clarify your position on the basis of new events. For instance, if there is the news about the fact that you were condemned in the first by the tribunal, you have the right to add also the information about the result of the decision in the appeal. This decision is a strange decision. In my opinion, is not completely correct, because the purpose of the archive is different from the purpose of a database in general. The purpose of the archive is to provide the picture of the journal at the moment in which it was published. If you ask to update your archive, you change the nature of the archive and you transform it in an updated database, like many other databases that exist. But this creates a huge burden on the shoulder of the media company, and there are already some cases in which small newspaper decided to close the online archive in order not to take any risk and to any cost, extra cost. After the Google Spain case, before describing the position after the Google case, we have to point out that if you read the 150 decision adopted by the Italian Data Protection Authority on this topic, the main problem is the lack of transparency. Because you don't know the fact, or you know a very few information about the fact. You don't know when the article was published, and you don't know, as a consequence, the time that passed between the first publication and the fact that there is still online the content. So these decisions are also adopted also a copy-paste solution. So they say that the media company say that there is a public interest. We check that exists a public interest, so the content should not be delisted, the index. Or another solution, that we know that there is not any kind of public interest, and so the content should be delisted. But if you don't know the fact, you are not able to check if the decision is correct or wrong. And this is a sort of paradox, because there is a lot of criticism about Google, the fact that its decisions are not transparent, but in Italy we have the Data Protection Authority that adopted official decision that is no more transparent than the other one. About the criteria are the same that were used in the past. The main differences is represented by the fact that now, after the decision of the European Court of Justice, the Italian Data Protection Authority recognized its jurisdiction and the fact that we can apply the National Data Protection Regulation to Google and in general to other search engines. is interesting in the core of the decision about the delisting injunction. About the delisting injunction is an unclear position, because the data protection authority said you have to delist this link, and the order is addressed to Google in some cases, not Google Italy, not Google Inc., Google in general. And also the listing is an order to delist, at which level we don't know, at national, at European level, at global level. So it's quite strange as approach, because this is a core element. There's a lot of debate, also recently after the position of the CNIL in France, there is a lot of debate about the effect of this kind of injunction. And in Italy we have this strange injunction. You have to delist. And only a brief anticipation about this case that will be decided by the European Court of Justice is not about the right to be forgotten in terms of media and protection of personal information, but is about public records. And in 0 minute, the problem is if there is a public record, in this case, the name of a liquidator of a company, do you have the right to remove this information from the public record after an adequate period of time? And if there is no specific provision in the law, could the court, the data protection authority, the entity that maintain these public records could remove, because the goal, the purpose of this information is no longer relevant. In the decision of the Corte di Cassazione on this case, in order to in the request of preliminary ruling, the position seems to be not in favor of the idea that you can remove this kind of information. Thank you.